And again, I can't say it enough. This satisfies our solemn obligation, again, to make certain that the public remains abreast of and has access to the public's business. So I will take us off of YouTube as we conclude the hearing. But at this time, I believe today has specifically been noticed for the defendant's motion to dismiss for lack of personal service. Ms. Lane, I believe that's your motion, if you would like to proceed.
Thank you, Your Honor. Yes, you're correct about that. So I just, because I'm curious and I wanted to clarify that. We're only on YouTube right this second. Afterwards, we can't go back and watch it.
Can't promise that, Ms. Lane. I've been promising that to litigants for some time now, but I think that I actually have to go to IT and delete it if we do not want it forever preserved, which I probably will do. But anyone who clicks on the court's webpage, which is fultoncourt.org, can actually go to my tab on the judges page, and when you click there, you have access to the YouTube.
Gotcha.
So
thank you.
I think it only should be live while we're going on, but I do probably have to take one more step.
I was curious because we have some young attorneys in our office. I was just thinking that I could direct them to watch some things for basically like we used to in olden times, have to go observe trials and stuff.
Right.
So,
well, if you do a really good job, then we can leave it up.
Thank you. I'll let you know at the end after I give your order. So I appreciate that little diversion moment for us. We are here on defendant Thanatil's motion to dismiss. The current posture of this case, as we all know, but just to review for the record, there is no carrier involved at this moment in time, although I know that Mr. Burke has appealed on that particular issue, and that is pending. I filed this motion because in the current posture of this case, it is essentially moot. There is no end game to be achieved for Ms. Isaac here because no judgment can be obtained against Mr. Thanatil, and there is no other party. Publication, of course, gets the plaintiff past the hurdle of service to keep a lawsuit alive. And I'm not going to argue about whether publication was right or wrong in this case, whether or not Mr. Burke was diligent or not diligent. I'm not saying, yes, I agree with all of those issues. I just don't think that they're pertinent to the substance of my particular motion in this matter. The ultimate end goal of publication would be to keep a lawsuit moving to a resolution point for all the parties. Of course, Ms. Isaac, I assume, wants money compensation for her damages. And unfortunately, the facts in this case just don't allow for that recovery against my client. Publication would give Ms. Isaac the right to pursue recovery from her own carrier, again, State Farm, or in very specific, very limited circumstances, publication might give a plaintiff the right to pursue recovery from a defendant, but those specific circumstances have not been met here. There's a case I did not cite in my briefs.
Ms. Lane, let me ask you a question, if I may. Is it premature to dismiss this case prior to the appeal being decided?
That is a great question. I got myself all up in my confused thoughts about that this morning because I thought, well, if I win the motion today, then what happens? Where do things go?
Right.
And so I think it would be akin, honestly, to any motion for summary judgment. You could rule on a motion for summary judgment in any case that was dispositive of a claim against one or more defendants, and the Court of Appeals could say that you had made the court had made the wrong choice and send that back, remand it, and that essentially would reopen it, I think, with the clerk's office. So I think we would be in that same position here today. So if the Court of Appeals determined that there is that the ruling on the State Farm motion was an error, then they would just remand the case and it starts again.
Okay, so I guess my second question, or question 1A, would be, is this has supersedious attached to a notice of appeal. Do I have jurisdiction to do anything right now?
Well, I think my issue is distinguishable from the State Farm issue, because what I'm trying to get the court to rule on is whether there's an in personam judgment as to Mr. Thanatil. And I do not know that that is addressed at all with the parts that are currently on appeal.
Okay.
But I'm certainly willing I will say, even on YouTube, that I do not know the conclusive answer to that question.
Okay, so, well, I guess, I mean, if you just look at this case, and of course, that's for those of us who do not live in the world of insurance defense on an hourly basis like you guys do, you see two parties. There's Ms. Isaac and Mr. Thanatil, and the question, I think, pretty quickly becomes, if there's a notice of appeal, you know, are you leaving some unnamed parties down here and some unnamed parties over there? That was really the question.
Right. I don't have I do know this even on YouTube. I don't have standing to make an argument one way or the other about the State Farm motion. That's, okay. I don't have a dog in that fight.
Okay.
I could probably file some sort of amicus curiae brief on the issue, but the Court of Appeals doesn't really care what I think or what Mr. Thanatil thinks about your decision or its ultimate decision on that issue.
Okay.
So from that perspective, that's why I think this is a separatable concept that I want to discuss with the court today.
Okay. So the notice of appeal filed by the plaintiff on December 20th, 2021 states that she appeals from the final orders entered on October the 19th, 2021, granting State Farm's motion for summary judgment. So again, I'm just trying to see how do you separate that out? And maybe that's a question for Mr. Burke. That's just my question.
Right. Well, and I think honestly, it's a little bit tricky or confusing to me because we don't, which we shouldn't, name insurance carriers in the caption, but it's essentially like a case where there are multiple defendants. If Mr. Burke had sued Mr. Thanatil and Joe Smith and either settled with Mr. Smith, or Mr. Smith said, it's not my fault, this was wrong, and filed a motion, the court could rule that Mr. Smith needed to be dismissed from the case. That wouldn't have any impact on me as a remaining defendant. State Farm's posture in the case comes about because Mr. Thanatil is not available to be personally served.
Right.
But Mr. Thanatil's posture in the case is not impacted by whether State Farm is here or not. If Ms. Isaac had never had coverage, I could still make an argument that he has not been personally served.
Okay, that kind of made sense.
Good, because I made that up, but I think it's true. So what I was saying is, in essence, we've covered a lot of that. But the main crux of why I think there is a distinction to be made and why I thought it was okay to do this even while that State Farm issue is being litigated is because the only way that Ms. Isaac right now could get money from Mr. Thanatil is if she had met certain conditions, and my argument is that those conditions have never been met. She could get an in personam judgment against Mr. Thanatil if, in the very specific circumstances under the case law, the court, Your Honor, had found that Mr. Thanatil had willfully and knowingly evaded service, and there had been an affidavit about that very thing filed with the court. But the court order from July 2020 that I believe was issued on July 1st of 2020 was silent on anything about willful evasion. It didn't address concealment. It didn't say that he was deliberately trying to hide from the court or in any way. In fact, it specifically says Plaintiff has shown defendant is not to be found within this state. So Mr. Burke.
So you're saying that personal or in personam jurisdiction, personal jurisdiction only attaches. So we all agree we've got service by publication, and I think we all agree that the court ordered service by publication, but you're now pushing that argument one step beyond on behalf of Mr. Thanatil by saying, but you can still only get a personal judgment if you show evasion.
Yes, ma'am. The case law says that that service by publication for purposes of this and for purposes under the UM statute 33711, et cetera, that's fine to try to get that UM money, but that does not change our Constitution or fundamentally held beliefs about a person's participation in a lawsuit. And the case law is clear that an in personam judgment cannot attach if a person has been served by publication because we couldn't find him. Now, if Mr. Thanatil is standing at his apartment door shouting at the sheriff's deputy, "I'm not coming out, I don't care about you," or we can see him, peeking between the window blinds, or his mom comes out and says, "I told him you were here, but he's not coming out of the door." That's a completely different scenario. None of those facts apply here. The plaintiff herself has acknowledged he is not to be found within the state. There is no willful evasion, and therefore there cannot be an in personam judgment. And if that's the case, as the posture of the case is right now, Miss Isaac can't have any money. There's nobody here to give her money.
Well, are you attacking my order for service by publication?
No, this is essentially I'm asking the court to make a decision, to make an order that now says, even with that service by publication, there is no remedy to be had for Miss Isaac in the current posture. Or if there is a remedy to be had, it's something that the Court of Appeals will tell us about down the road. There's no remedy to be had from Mr. Thanatil personally.
Was the order for service by publication, is there some unique feature to uninsured motorist coverage? And I'm genuinely asking, please don't judge me. Is there some unique provision under uninsured motorist coverage that does allow for recovery based upon service by publication?
Yes.
Okay.
Yes. That is
so therefore we can treat State Farm different from your client.
Correct.
Are you an insurance company?
Well, I can't go on the record. Yeah, that's
okay. But so again, and just pardon me because I don't have the luxury of hearing a lot of automobile accident cases in the Superior Court. I get felonies from early in the morning until late at night. So does essentially, I think what I hear you saying is the individual driver of the car, defendant, gets treated different from his uninsured motorist coverage in terms of determining whether there is in personam jurisdiction.
Differently from the plaintiff's uninsured motorist coverage, but otherwise that's 100% right.
Okay, all right, that helps. Okay, now okay. And we're waiting on the Court of Appeals to tell us whether the decision on the summary judgment, I think it was summary judgment, was correct for State Farm.
Yes, ma'am. I don't have that pulled up, but that sounds correct.
Well, what remains of the case, I guess, is just, again, I kind of get back to the supersedious argument. Would you mind, Ms. Lane, if we just go ahead and hear from Mr. Burke and let us hear what he, Mr. Burke, how are you doing?
I'm doing okay, Judge.
We've been worried about you.
Yeah, I've been worried about me too, but I appreciate everyone's thoughts and prayers. I'm still here. I'm grateful to be alive.
Well, it's very good to see you, and you look great. And when you're ready to tell me what to do, go ahead.
I tried that the last time, but you didn't listen to me. So
I'm hard-headed, but try again.
All right. So, Judge, I kind of agree with counsel on the posture of the case where it is today. I do want to get into some of the facts, but let me address the supersedis argument. We did file the notice of appeal after we got the discretionary. So it'd be my position that the Court of Appeals now has jurisdiction, even though the case has not been docketed, and that this court would not have jurisdiction to rule on any motions related to this case. So that would be my first argument. And we haven't received anything from the Court of Appeals since we filed a notice of appeal. And we just checked the docket to confirm that, because I was hospitalized until March the 11th is when I got out of the hospital. But, as it relates to the merits of the case, what counsel is arguing is essentially that Ms. Isaac would be precluded from recovering from them as well because they were not served personally. Our position is that the order granting service by publication does speak to the issue of him avoiding service. And we pointed out in our brief what we contend the events that he engaged in comprise of his willfulness in avoiding service. They include never contacting the sheriff's department after notice was left. And I would say, as a caveat, if he was moved out of the country during this time when we were trying to serve him, then, obviously he wouldn't be able to contact the sheriff's department. But we don't know the answer to that question as to when. The only thing we know is that the sheriff's department went out there several times, left notices for him to contact the sheriff's office. We did a postal service. I know counsel argued in her brief that it doesn't matter whether or not he left a forwarding address because the postal service would charge him additional fees to forward it. And that's still on him. It's incumbent upon him to do that. Normally when people move, they do a forwarding address to get their bills, subsequent bills, or important mail. But we think that the fact that he did not leave a forwarding address and did not pay whatever the cost was for the postal service to forward the mail to him was part of his efforts to avoid service. Sort of, I'm done with Georgia. Everything that's happened in Georgia is behind me. The other issues, facts that we contend show that he was avoiding service was that the current tenant advised that he was not living there anymore. Of course, he has a right to move, but again, that goes to the fact that he didn't provide the postal service with the forwarding address. Even his social media page was private, so we couldn't find any information as it relates to where he lived. It was only after we served him and found out where he worked that we discovered that he moved to India. And then that brings us to the second argument, is that even if the order doesn't specifically outline or find that he's avoiding service, we think under the Hague, service of process was proper. And we outlined that in our brief with the declaration that was filed after we filed our reply brief from the company we hired, where they say specifically under the Hague statute, and that can be found in paragraph, hold on a second, Article 15 and paragraph, let's flip through his affidavit. His declaration, paragraph 5, in her declaration, I'm sorry, Maria Gutierrez And she outlines that under the Hague, that if we did all of these things, which we contend we've done, and it's A, B, and C, that this court under the Hague would have jurisdiction despite the fact that the defendant was not ultimately served personally. So we contend that A, the order does find that the defendant was trying to avoid service based on the facts that we outlined in our brief, and B, that even if it doesn't, that under the Hague Statute, Article 15, and the declaration that was submitted establishes that this court would have personal jurisdiction over the defendant, and therefore
Do you agree, Mr. Burke, that personal? I mean, this may sound silly, but do you agree personal jurisdiction would be required? Obviously, I guess.
Yes,
Okay.
yes, I do agree. I'm not saying it does not, is not a requirement.
Okay, I'm going to get back to Ms. Lane, but let me pose this situation. Let me ask this question for both of you, and I'm going to ask Ms. Lane to answer it first. Now I'm hearing from Mr. Burke, so two different questions. Now I'm hearing from Mr. Burke that there are facts which are perhaps disputed as to service. Does that convert this motion to dismiss into more of a motion for summary judgment? Or I hope you get what I mean. So that's one set of questions. And the second set of questions is now I think I'm staring at the possible outcome that I have two non-named entities with two possible outcomes, both of which are probably going to end up on appeal, with an appellate court telling me what to do with these two. And this may not be unusual in the world of uninsured motorists. I don't know. I doubt this is the only situation where we can't find the defendant. But am I going to end up with two different rulings based on two different non-parties? Okay, Ms. Lane, you go first. Good luck with those.
Thank you. It does come up pretty frequently about service by publication as it relates to uninsured motorist coverage. And in fact, this case is very similar in that regard to cases that I cited in my brief. The order that Mr. Burke was referencing was the October 2019 order, and it did not enumerate specific findings by your honor, by your court, about concealment. It said defendant is either purposely concealing himself or cannot be found. Well, that's not a specific finding of concealment. And to the extent that Mr. Burke's recitation of the facts was about Mr. Burke's diligence, I'm not questioning that at all, to be clear. I'm not saying that his office didn't make every effort to be diligent. Whether somebody, the sheriff's office leaves a business card at the doorway of a house someone presumed to belong to Mr. Thanatil, and Mr. Thanatil did not respond to that business card, that's not in effect evidence of concealment. If he wasn't there, him not forwarding his mail is not evidence of concealment. Lots of people move and don't forward their mail. Furthermore, unless he knew a lawsuit was about to be served on him, the failure to forward his mail is just a personal choice that he made. If I move, I may or may not forward my mail if I know that my credit card company already has, I've contacted them directly for my new address. I don't want all my old junk mail magazines and flyers about trash service or whatever it may be. That doesn't mean he is willfully concealing himself. It's just a choice he made because he didn't know anybody was going to sue him. Now, as to the question,
let me sort of divert for one moment, and I apologize for doing this, but this case isn't, there's no final judgment in this case. So maybe that order, as you say, of October 2019, maybe there was no certificate of immediate review or anything like that, but is that order ultimately appealable upon a final judgment?
Well, I'm not sure that that order is, valid's not the right word, because we did litigate that order to, well, sort of, to determine that the publication hadn't happened properly. We argued that with you, I don't know, before COVID, so whenever that was. And so that order, in essence, was superseded by, I'm saying the October 2019 order was superseded by the July 2020 order.
Okay.
Because we all came together and you decided that we were going to forgive the fact that the publication didn't happen properly. That essentially wasn't Mr. Burke's. It was not within his control to make it happen the way it should have happened. That was a newspaper error, basically. So that subsequent order is the one that really should be the order on service by publication. There was an opportunity to discuss in that order whether willful concealment was a factor or not. And even, I'll say this, even if we're going to go back and rely on the October 2019 order, it doesn't say that Mr. Thanatil was purposely concealing himself.
Okay.
There's no specific finding of that in that order at all. At least it has the words in it that time, but it doesn't make any specific findings about it. You were asking, though, if you could end up in a situation where there's sort of two different appellate issues with two different, at that point, non-parties. And I do concede there's some, I don't know the answer about what we should do with a lawsuit if I ask you to get rid of the whole lawsuit, what happens if State Farm is wrong? Or if the court was wrong about State Farm's posture? What do we come back to? What I'm essentially asking the court for is a finding that Mr. Thanatil has not been personally served in a way that would precipitate an in personam jurisdiction, a bonus guest, and that there's not any evidence of willful concealment and no in personam judgment can be had against him. Miss Isaac at this point is precluded from recovery, except as to the extent she may have a remedy to investigate why State Farm was not timely put on notice, or whatever State Farm's argument might be. She can investigate that and pursue a remedy in that regard. I forgot what your second question was.
No, so again, I'm sure that there are plenty of precedents out there on this issue, but I guess what I'm confused about, what I'm confused about is what comes back. Who do I have?
Right.
I have a nominal defendant, essentially. That's all. I'm just, if the Court of Appeals reverses me on State Farm, essentially it's Megan Isaac versus Megan Isaac, but
it would still be Megan Isaac versus Anish Thanatil, but
do you have to keep steering?
No.
Do we get the other person? I can't even remember. We get State Farm.
The State Farm would appear under the pretense of being Anish Thanatil's.
And you've won because your client is very happy.
Correct.
Okay. All right. Now, did you answer the other question? I think you did, about are we looking at facts? And that was where we talked about the July order versus the October order.
Right.
You're saying facts aren't in there anywhere. I'm entitled to my motion to dismiss because there's no way they can win.
Right. So if your October 2019 order had said ABC, as Mr. Burke just recited them to us, and made findings about that, then that would be a different conversation for us to have today, but that's not in there. So I don't think it's about the facts. It's about what we do have. And to the extent that that's helpful to you, the supplemental brief that I filed on March 2nd, there are several cases with very similar fact patterns of a service by publication and no specific findings in an order and what happens after that. So there is precedent there.
Okay. Okay, Mr. Burke, you wanna end us up today?
All right, let me try to answer the court's question about what happens in an appeal. So if we are successful in convincing the Court of Appeals that State Farm was wrongly decided, then the court obviously would send it back. State Farm would still be a party. So the EUM issue would still be there. But the underlying issue that we're dealing with today, the court is correct that we probably will appeal that order if the court rules against us. And that's because we think that there was specific things that this defendant did that are tantamount to willful concealment. And one of the things I failed to bring up was that we asked counsel for the defendant if she would acknowledge service because of the issues we were having. And presumably counsel would have had to discuss this with her in short. And I'm sure she's spoken to him despite the fact that he's in India because he's still a party to this lawsuit and he filed a special appearance answer. And she said that she was not authorized to do that. Well, obviously she spoke to him and he said, no, I'm not going to acknowledge service. If that's not willful concealment or willful avoidance of service, I don't know what evidence is. But if this case is ruled, the court rules against us adversely, we would ask the Court of Appeals to send the case back with the instructions to either tell the trial court that there needs to be a specific finding like counsel is arguing. And the court can actually right now amend that order based on the evidence in the record that these events that I listed rise to the level of willful concealment or avoidance of service. So
now wait a minute, Mr. Burke, you can't have it both ways. I can't tacitly decide whether I put it in an order or not. I can't tacitly decide that, look, this case is on appeal. Under the provisions of 5, 6, whatever it is, I don't have jurisdiction. The case is supersedious is in effect. I can't say that, but I want to go back and start changing orders. Can
I agree with you, Judge. I agree with you. And that's not what I'm saying. I'm saying that if this court decides that it has jurisdiction to rule on this issue, then the court, it would be the same thing. The court would say, okay, and I can amend my previous order to include specific, finding that. And we don't think you need to do that. We think that that language in the order and the fact that we argue these things in our brief satisfies that requirement. Counsel is arguing that, you need to find specifically that he did X, Y, and Z, and that is tantamount to willful concealment. We argued that he willfully concealed himself. When we pointed out that we asked him to acknowledge service, he refused. We pointed out that he didn't leave a forwarding address. We pointed out he never responded to any of the sheriff's notices, and the sheriff left several of them. And again, all of this is based on the fact that we don't know when he moved to India, but that's incumbent upon him to tell us that. Otherwise, the only conclusion we can make based on these other things is that he's avoiding service. And then even if, and this is the other part of my argument, Judge, and I don't want the court to think that this is less important because it is very important than the issue of willful finding that he was concealing himself, is that under the Hague statute, he's been served based on the paragraph of Article 15 of the Hague that sets out that if the process server or the judicial officer in India goes through and makes these steps, it takes these steps, that despite the fact that the person was not successfully served, this court here in Georgia could find that service on him was proper pursuant to Article 15 of the Hague.
Well, listen, this has been wonderful. I will get something out to both of you as soon as possible. I want Mr. Burke, again, I'm constantly hoping for your improvement and your healing, and I want everybody to have a great weekend. And Ms. Lane, you tell your associates and others that you did a great job and they should watch you closely. So thanks, everybody. Thanks, Mr. Newman. I hope we get to see you again, and we'll get something out as soon as possible.
All right,
Thank you all.
Judge.
Okay, thank y'all.
Thank
Okay,
you.
wait, I gotta go up here.
Ms. Lane, can I just ask you